Could the intellectual property rules be causing vaccine apartheid?
The Copyright Act is unconstitutional on the basis that it limits constitutional rights.
When I was diagnosed in the year 2000 with HIV, my dad, who's earning a minimum wage, couldn't afford to go and buy ARVs.
When it comes to education, learners from Limpopo to Lagos experience difficulty in accessing pricey textbooks.
As blind people, we do not have access to information and knowledge.
Braille becomes a crime.
There's no point from the perspective of a child without a textbook of copyright existing at all.
Welcome to the Big Debate. I'm Redi Tlhabi. Thousands of people in poor countries died of COVID-19 in 2021. Whilst death rates in the US and Europe plummeted, most countries in Africa continue to be highly vulnerable due to the lack of vaccines. Yet many experts believe the world has the ability to put in place manufacturing capacity to make enough vaccines for everyone. So why don't we? Vaccines are made by private companies who own the patents. Hence, they choose how much to make and they set the prices too. Could the intellectual property rules be causing vaccine apartheid? When it comes to education, learners from Limpopo to Lagos experience difficulty in accessing pricey textbooks. Intellectual property rules prevent teachers and learners from making and sharing copies, even extracts. Why are global companies so reluctant to sell their products to a mass market in the global south? Why do we grant them the monopoly power that means they don't have to listen to our needs? At the height of the AIDS epidemic in 1995, millions of South African lives were at stake. It was only when we threatened to ignore the patents and make our own generics that drug companies reduced their prices to make medicines accessible. Is it time for similar tactics again? Joining me for this conversation are Fatima Hassan, founder of the Health Justice Initiative. We have Sanya Santani, copyright and human rights expert. Owen Dean, intellectual property lawyer, as well as Sibongile Shabalala, national chairperson of the Treatment Action Campaign. We also have Ivo Vector, freelance journalist and independent researcher. And of course, in our virtual audience are health and education activists and diverse South Africans interested in access to knowledge and healthcare. Thank you so very much, everybody, and welcome to the Big Debate. Don't forget, you at home can join this conversation by following the hashtag on your screen. Fatima, let me start with you. You have supported the call for a waiver of intellectual property that was also called for by President Ramaphosa and India as well. Essentially, doesn't that mean you are asking the manufacturers to share the family's secret recipe? If they made the inventions, do they not have a right to decide on pricing? Are we not trampling on their rights to demand that they just make available freely that which they invented and worked so hard for?
So the first thing I would say is that it's not their vaccine, it's the people's vaccine. We say that because considerable amounts of public funding and public investment went into the research of these particular vaccines so that you could get them onto the market so soon. And it relied on the knowledge and the innovation of scientists before. There is a current dispute between the US government and a company called Moderna as to who actually owns the IP of that particular vaccine. So when we're talking about family secrets and family recipes, I think we have to be a bit careful about whose innovation it really was. And then we have to ask the following question, that even if it was exclusively the knowledge of Moderna or Pfizer or Johnson & Johnson, in a pandemic, you cannot insist on exclusivity. In a pandemic, you have to be able to make life-saving interventions available to everyone, everywhere.
Sanya, let's talk about education. Like patents, copyright is the intellectual property of the manufacturers to prevent the rest of us from making copies of books and journals and textbooks and so on. There is currently a proposed law in South Africa to make exceptions when it comes to textbook and learning material. President Cyril Ramaphosa seems to be stalling and has not signed that law into existence. It's raising concerns that a waiver of copyright, making exceptions of copyright, means that we are expropriating other people's property. You disagree with that. Tell me why.
I think we've got to be clear at the outset. There's a difference between a waiver, which Fatima was talking about, and exceptions to copyright. Now, exceptions to copyright have been a part of the international copyright architecture since 1886, and exceptions specifically for educational purposes exist in every country that has a copyright statute. Now, the question about whether restricting copyright is an unconstitutional expropriation of property. I think very clearly that these provisions in the Copyright Amendment Bill definitely do not amount to an unconstitutional expropriation of property. But it is a multi-layered question, and we've got to start with the first question underneath that, which is whether copyright is constitutionally protected as property under Section 25 or not. It must be noted that no court until today has held that copyright is property under Section 25. But in any event, let's assume that it is property. The right is not absolute, as I told you already. On expropriation specifically, these exceptions that we're talking about here, they don't take away the whole of the copyright and give it to someone else. Rather, they simply allow for limited use for a specific constitutional purpose. Even if it can be argued that there's some amount of deprivation, the Constitution only prohibits arbitrary deprivation of property. And where we're talking about the right to education in the Constitution, that cannot be said to be an arbitrary deprivation of property.
Maybe tell us in a few words why it is important to have these exceptions to copyright when it comes to educational material.
A study from the Print Industries Cluster Council demonstrated that only 4% of the South African population have the purchasing power to buy books. And that's just simply because reading material is just too expensive for people to purchase. So that's one. And the second is people living with print and visual disabilities are also marginalized because copyright requires them to seek permission from the copyright holder in order to convert a particular work into Braille or so that their text-to-speech software can read it. Now, a high court in Pretoria has held that this is unfair discrimination and that the current Copyright Act is unconstitutional on this basis.
Oh, and let me bring you in here. What is wrong with making copies of textbooks during a book famine or vaccines during a pandemic?
The world at large has decided over a period of in excess of a century that in order to encourage people to create works and inventions and so forth, they need an incentive. And that incentive is created by giving a monopoly in the use of the work or invention that's created for a limited period. And thereafter, the work falls into the public domain. So the system is set up to enable the creative people to basically earn a living. Now, when you grant exceptions, you are eroding that right, which is universally recognized. It's played a big role, in my view, in all of the development which has taken place in the past century. It is true that when you grant rights of that nature, which are quite far-reaching, you impact to some extent on the general public good. And so what intellectual property law recognizes is that you try and form a balance between the rights of the creative person and the rights of the public at large. And where that balance falls is quite a difficult issue. I personally agree that there should be some form of relaxation of the patent rights in a situation of crisis, which is what we have with COVID. As an intellectual property protagonist, I can live with granting some sort of relaxation or waiver there. I'm less sanguine about doing the same in the case of textbooks because you've got an author who writes a book. He relies on the income from the sales of his books to earn his living. You've got publishers who incur very vast costs in setting up, printing the books and so forth. Now, if they don't make a profit, they're not going to make books.
Is profit the only concern? And Owen, I'm going to put on my author's hat, if you can just indulge me, because I'm a writer too. Is it really true? Have we tested that when it comes to investing in our nation, creators are necessarily always looking for money? Isn't impact and building society, social justice, also a good motive to create?
Certainly, they play a role. I mean, I have written books myself. I've written 2 textbooks. Part of your motivation in writing books like that is to help other people understand what the law, in my case, what the law provides. But at the same time, I come back to the point there has to be a balance. I'm all for exceptions. I mean, the exceptions have been in copyright law for the past 100 years. There's nothing new about that. It's a question of the degree of the exception. Now, in my view, the current Copyright Amendment Bill swings the pendulum too far in favor of the people who want to copy, to the detriment of the copyright owners.
All right. Let's just bring in Ivor. You've written quite a scathing column where you challenge the leadership of Cyril Ramaphosa, saying that he's going around with a begging bowl. He does not have a right to demand that the creators, the manufacturers, give up their control over their innovations. During a pandemic, isn't there a moral issue as well? So why not make exceptions to patents when it comes to a pandemic that nobody chose?
I think that argument has a lot of validity when you approach pharmaceutical companies, for example, or foreign governments and say, look, we are not in a position to manufacture vaccines ourselves. We are poor. We cannot afford the prices that some of these manufacturers charge. Would you help us? And I think you'd find very favorable response to that sort of request. But to say that justifies waiving the intellectual property rights, which are set under treaty in the TRIPS agreement, firstly, I don't believe that intellectual property rights are a substantial obstacle to countries that are struggling to acquire vaccines. But countries that can't afford to buy vaccines, they won't have the capability to manufacture advanced vaccines either.
So relaxing the patent is not going to help them because of manufacturing capacity. That's what you're saying.
No, exactly. If you think of these mRNA vaccines, it's an extremely complicated operation, which only the most sophisticated laboratories in the world can perform.
Is that a fair point, Fatima? Even if we were to relax their intellectual property, there's no manufacturing capacity. You're saying no. Why?
I've been doing this work for 25 years, and we heard this racist nonsense during the HIV/AIDS crisis as well, that people in poor countries can't make, good quality generic versions of ARVs, and we showed that we did. The waiver is within the rules of the TRIPS agreement. It's a mechanism that is actually allowed by the WTO. So this was not Cyril Ramaphosa going with the begging bowl. The waiver is not just for vaccines, it's for diagnostics and therapeutics as well. It actually allows countries to be able to use those flexibilities to temporarily pause the application of intellectual property rules, particularly in a public health emergency. And this pandemic is a public health emergency. It's a crisis. Because these vaccine companies and their CEOs have decided the types of licenses that have been issued, which companies in which parts of the world get to make copies of these vaccines, or only 2.8% of the 7.6 billion doses have actually been administered in Africa. The point is there were not sufficient supplies. There still aren't sufficient supplies to be able to vaccinate everyone. South Africa has been an outlier and different because we had strong civil society pushing our government to enter into bilateral agreements and not just to rely on COVAX. We found out from the New York Times when it did its investigative story that Johnson & Johnson was using a company in South Africa called Aspen to fill and finish vaccines for Europe. So that racist assumption that countries in the global south, and particularly in Africa, can't make vaccines is basically, I want to say, just really disingenuous. We have an mRNA WHO hub in South Africa. Soon there may be one in Rwanda and Senegal. The companies are not coming with the technology to cooperate to make those hubs successful.
Okay. Sibongile, you've been nodding there. Just on what he said, that we must just ask them to share their technologies, ask them nicely, as it were, that it's not an obligation that they have. What do you say?
If they are saying we must come and ask nicely, the question is, who are these innovations made for? If they are making them for themselves, they should keep them to themselves. But if they are making them for people, they need to think that there are people who need them. This is not about South Africa only. To say South Africa can afford, that doesn't mean that Mozambique, Zimbabwe, and other neighboring countries can afford. So we shouldn't be selfish.
Ivor, isn't that a fair point, that it's not so much about South Africa, it was about countries in the global south?
Indeed, and that's why I pointed out that there are mechanisms and organizations that can help these countries acquire vaccines. I just want to respond to a couple of things that Fatima said. There seems to be this sort of entitlement that because these foreign companies make these vaccines, that we somehow have a right to these vaccines. Why were they made in the first place? Well, they were developed by companies that were established in countries that developed their own economies through free enterprise and free trade and so on. Their governments put up hundreds of billions of dollars or euros to fund pre-orders from multiple potential manufacturers. Now, a few of those manufacturers were successful. They fulfilled the pre-orders and they made money. But many others were not. Right? So that was just a dead investment. Now, by what right do we turn around and say, well, we have a right on those vaccines on an equal basis with the people who built the pharmaceutical companies, who paid their taxes and who risked their money to pre-order them? So that to me is an issue. And then when Fatima said that Aspen shows that we can manufacture in our own country. What Aspen does is they import the J&J vaccine liquid, right, and they bottle it, right, and they do not have the capability of manufacturing the vaccine. There's a process in place right now whereby there's a tech transfer to bottle the Pfizer vaccine. It started in June this year, and it will finish sometime next year, 2022. That is how long it takes just to learn to bottle these things. Right? Now, to learn to actually manufacture the vaccines will take years.
Okay, let's go to Kate from MSF.
That is a misrepresentation. We do have the capacity to go beyond fill and finish. Some of the research has specifically looked at that capacity. mRNA, it is also possible that that can be made here. That's why Afrigen are hosting the hub. The WHO have given them that opportunity here in South Africa. But there's also capacity elsewhere on the continent with manufacturers who've had the ability to do injectable medicines. So for you to keep saying that we don't have that capacity is a complete misrepresentation. Furthermore, I just have to remind you of what Fatima said early on. These vaccines actually were often publicly funded. In the case of Moderna by the United States government, the United States government have recently come out and said that they are in support of the waiver. It's just time that we actually have more countries come out in support of the waiver. The majority of the world does. It's the European Union that continues to block it.
When we return, we delve deeper into the world of Big Pharma, the risky investments, miracle cures, mega profits, and millions of lives at stake. Don't go away. Welcome back to the Big Debate. We are talking about access to medicines and access to knowledge. In most wealthy countries, over 60% of adults are fully vaccinated against COVID-19. Across most of Africa, less than 2% of adults are vaccinated. By March 2021, around half the global supply of vaccines had been brought up by wealthy countries that make up less than a fifth of the world population. Since then, companies have done little to make their vaccines available cheaply. We've been here before, remember? In the late 1990s, several million South Africans were living with HIV, and the price of antiretroviral treatment was 200,000 Rand per person in today's money. Completely unaffordable, of course, for anyone except a few rich, mostly white private patients. Sibongile Shabalala, you have been living openly with HIV for over 20 years. And I do remember with a lump in my throat the many lives that we lost, first because of HIV/AIDS denialism by our own governments, but also because ARVs were not accessible and they were not affordable. How did it make you feel as a person living with HIV?
Firstly, when I was diagnosed in the year 2000 with HIV, it was difficult because I was just waiting for me to die. There was stigma and discrimination. Every day I was sitting there fighting for my life, knowing that any day I could die. And at that time, even if where ARVs were available for those who can afford. So for my dad, who's earning a minimum wage, couldn't afford to go and buy ARVs. So what we had to rely on is what the doctors at the clinic, at the hospital, they are giving me. But every 3 months, 4 months, I will be admitted in hospital with different illnesses. So it was very difficult until I lost my husband in 2004, where I lost him because of HIV. And that's when the fight against ARVs was like, now the government has to provide ARVs.
ARVs are available cheaply now, but at that time, South Africa just threatened to bypass the IP and produce generics. We actually launched this mammoth battle with international pharmaceutical companies. Tell me about that moment.
As we are saying, we had to fight with our own government first. And after fighting with our own government, now we had to fight the pharmaceutical companies who were threatening to pull out because we wanted generics, because they didn't want to lower prices. It wasn't easy because we were threatened by so many companies and also people who had power. Remember, countries like South Africa, as much as we say we are independent, we are still relying on business to make our economy be stable or be able to carry on. So it was difficult also for government, but because they had a constitutional obligation, they had to fight with us in the court.
Fatima, what did we learn from that period?
We learned from that crisis that patent monopolies actually cost lives. Around the world, millions of people died because they couldn't get timely access to these ARVs. And that is the lesson that is basically encapsulated in what's called the Doha Declaration under the TRIPS agreement, which one would have hoped that we would be using those flexibilities in this pandemic. And the waiver is a solution to try and make sure that we don't even have to use the declaration and its flexibilities and to have a temporary suspension of intellectual property rules. But the amount of opposition to the TRIPS waiver shows you that there is now an existential crisis, particularly in the pharmaceutical industry, because there is an antagonism towards making life-saving medicines and technologies publicly available as a public good. There is an insistence that they should be continued to be commodified.
All right. Owen, can you just come in here? I mean, that experience in the 90s, early 2000s, fighting over IPs on ARVs and so on, we did prevail ultimately, but at a great, great cost. Doesn't that experience with ARVs tell us that the entire IP system is broken and needs dismantling?
Well, I wouldn't agree that it's broken or that it needs dismantling. It fulfills a very useful purpose. But I think one has to differentiate between the law and the politics. Waivers can be made under the TRIPS agreement. In our own patent law, there is an ability to apply to the court for a compulsory license. Very few people seem to want to follow that route, which is surprising because that's an obvious route to follow. So if there is the political will, the law can accommodate steps being taken.
Sanya, maybe come in there on the exceptions matter, but also just to pick up on what Ivo said, that part of the reason you have copyright is to encourage the creatives to invest in research and development. Is that not a valid argument?
It's not a question of validity. I think we must look carefully at the ecology of how access to knowledge actually takes place in the copyright framework. So let's be clear about who makes money and how much they make from the market created by copyright. Many authors, especially authors of educational materials, are salaried academics at institutions that are publicly funded in some capacity. And we've already discussed where the money for the vaccines and healthcare technologies has come from. So it also must be noted that in the context of copyright and educational materials, many authors don't actually get compensated for academic articles in journals. But at the same time, publishers of journals continue to charge high prices for journal subscriptions. Now, this is not a problem that is only in the Global South.
Salome Meyer, you want to come in here talking about access to vaccines and the patents around that.
Yes, in South Africa, compulsory licensing is in the law. However, we have not once used that successfully in this country. The reason is because it's a legal process. And who will have the money to actually fight that? There's not been one case in South Africa that has been brought to the courts because it will take us years. And that is why particularly the Fix the Patent Law campaign is focusing on patent law reform. And we've been asking for it for 12 years. Yet, there is absolutely nothing happening. There is silence from the Minister of Trade and Industry about that. We have been marching to his office many times. Nothing is happening. So the question actually is why on the international front, we really are playing the role of saying, yes, let's do the waiver. Locally in South Africa, we actually not walking the talk. And that is part of the problem for not only just vaccines, but it is also for other life-saving medicines.
Thank you so much, Salome, for that. I just want to go back to Ivo. I mean, Ivo, we were talking about ARVs and that period in the 90s and early 2000s. We did not get ARVs by being nice. We actually defied, as a country, those pharmaceuticals, and they threatened to walk. We threatened to make generics. So surely it is time to do the same with COVID vaccines.
I agree with you that we played hardball and we won in this case, but we won a global PR battle in a way. You know, I think what we did from a trade relationship perspective was pretty harmful to the country and in particular to the country's relationship with global pharmaceutical companies. They now don't trust South Africa. In the end, the inability to supply enough antiretrovirals to AIDS patients, one was an issue of AIDS denial for years, and then had a lot more to do with corruption and stock theft. It ended up having little to do with access to the actual intellectual property rights. The reduction in cost of AIDS medication was a result of pharmaceutical companies that agreed to then sell their drugs at deep discounts and not to large-scale local manufacturing. And I think we're going to see the same here. This waiver process, this under TRIPS, takes years.
Fatima, can you come in here? We do have a comprehensive HIV/AIDS treatment policy and rollout, but also the issues that Salome raised, that we're not walking the talk here at home. There's no reform of the law.
It's shameful that the Parliament of South Africa, in the middle of a pandemic, has not accelerated the passing of the Patent Amendment Bill. If that bill were to be passed, we would not be TRIPS plus. We wouldn't have provisions in excess of what the TRIPS agreement needs. And it would also give civil society to be able to oppose a patent before it's granted. I think there's some revisionism about how ARVs actually got into the public and private sectors in South Africa. It was despite the South African government. The only thing they did was to try and pass medicine laws where they was then sued by the pharmaceutical industry. It was actually a PR disaster for the International Pharmaceutical Association, not for the South African government. We then had to step in. All of the volunteers of the Treatment Action Campaign, we had to take these drug companies to the competition court. And when we said to them, disclose to the country what it really cost you to make these ARVs, they didn't want to. What they then did was agreed to issue multiple voluntary licenses to manufacturers in the global south. That is how we got ARVs into the public and private sector in South Africa. But it proved a very important point, that there are companies in the global south and in Africa that if the knowledge is shared with us, you can have full manufacturing. There is no reason that Johnson & Johnson should be withholding a full manufacturing license from Aspen right now on the COVID vaccine.
Let's go to Andrew. Andrew Lentz.
Professor Teen and Ivo have claimed that we need the incentive from copyright or patent in order to create new things. For my doctorate, I looked and we don't have any economic evidence that we need these incentives. There's no competition to tell us how much. Because when you hand out a monopoly, you don't get a counter pressure that somebody's going to undercut it. It's a monopoly. But what we do know is that there's no point from the perspective of a child without a textbook of copyright existing at all. And there's no point for billions of people in the developing world in there being a vaccine if they can't get it.
All right. When we come back, we speak to a group of South Africans who had to march to the union buildings and take the government to court to force them to waive intellectual property laws. This is The Big Debate. Welcome back to The Big Debate on access to knowledge and medicines. In 2018, Parliament passed the Copyright Amendment Bill. The new law made it legal to translate books into Braille even without permission from the copyright owners. It introduced fair use of copyrighted materials for education and other limited purposes. It even made it legal for teachers and learners to copy whole textbooks when those books are not on sale at a reasonable price. International publishers and media companies lobbied the president not to sign the law. The US government even threatened trade sanctions. After sitting on his hands for a year, President Ramaphosa sent the law back to Parliament, saying that it could lead to expropriation of property. Blind South Africa took the government to court. Take a look at this.
The Copyright Act from 1978 does not allow permission for material to be converted into accessible format. So if you do that, you break the law. Braille becomes a crime.
In a major victory for blind and visually impaired people, the Pretoria High Court in September declared the Copyright Act of 1978 unconstitutional. The court ordered the reading in of Section 19D of the Copyright Amendment Bill, which allows for published works to be made available in accessible formats for people living with visual and print disabilities.
We have a book famine because only less than 0.5% of publications are actually available in accessible format.
I'm busy now with my PhD project, research into South African jazz pianists. And when I have to read a document, there's also another challenge because then you have to ask the printers permission for them to give you the electronic copy. And there's a 50-50% chance that you might be successful as well. So it's expensive in the sense that it costs me knowledge.
Whilst blind South Africans won a limited victory, the battle still rages over the rest of the Copyright Amendment Bill. On the one side, teachers, learners and activists who say they need greater access. On the other, large media companies and publishers.
The challenge we have in this bill is that fair use is very broad. When you allow students and lecturers to be able to copy textbooks freely without compensation, whole textbooks, you create less incentives for the authors to write material, to update the material, to keep it relevant because the compensation is not there.
Teachers from the blind community believe that the fight is about access to knowledge for all.
It even affects, people that can see generally. I mean, I'm teaching a lot of students that are doing choral music. And as far as my experience is concerned, they've always been using copies all the time because, they from schools that don't really have access. Copyright really is a symbol of imperialism, is a symbol of selfishness, and it can, only help the self if the self is fortunate.
All right, let's hear more from Blind SA.
It is crazy that we live in a democracy, and as blind people, we do not have access to information and knowledge. We had to negotiate with government for years. They kept on promising, and it took us to go to the Constitutional Court initially in 2019 to force the president to take a decision to remit the bills back to Parliament. We then felt that we needed to go to the Pretoria High Court because the 1978 Act is unconstitutional. It does not provide for us to transcribe books into accessible formats like Braille or DAISY or large print. The High Court on the 21st of September this year declared that the 1978 Act is unconstitutional.
All right, let's hear from Sanya. Sanya, just talk to me about why the president has not signed the law and the significance of this case. What do we learn from it?
So really, this case, the Blind SA litigation, taught us that the Copyright Act is unconstitutional on the basis that it limits constitutional rights. And it also showed us that the Constitution's promise that it contains within it is one that is for everyone and not just for whom the market has decided to cater to, what the president raised when he sent the bill back. The president raised procedural concerns on the basis of which the bill has been retagged, which means it will have to go through a further delayed process of public consultation. What was also raised was a lack of public participation on fair use. But just this week in Parliament, the Minister for Trade, Industry and Competition emphasized that he has not seen another bill that has gone through as much public participation as the Copyright Amendment Bill. And thirdly, the president raised a concern that the educational exceptions and library exceptions were too broad, as Professor Dean had put it, and also that they may run the risk of infringing on this right to property.
But Professor Dean, you do support exceptions, right, to copyright when it comes to the right of blind people to access books. You stop at a general exceptions for all learning material.
I do support an exception for the blind. I don't support exceptions across the board. I think exceptions should be dealt with on a case-by-case basis, and if there is a merit in a particular exception, it should be granted. This amendment bill, as far as I'm concerned, is an extremely poor piece of legislation. It is technically very badly drafted, and that is the cause of half of the problems. It seeks to introduce a very, I think, dangerous form of exception, which is commonly known as fair use, which boils down in practice to a judge having a pretty free discretion to decide that something is an exception. There is no clarity as to what is covered by an exception. You will only find out when the matter has gone through about 3 different courts and the court makes a decision. And in my view, that cannot operate in South Africa.
My question is more around the socioeconomic realities in South Africa. You have said you support exceptions for the blind community. But there are some schools that are not even worthy of being called schools. Children learning in dilapidated buildings, under trees, and so on. Would it not be fair for pupils in those communities to have the right to copy textbooks so that they can learn? Isn't that good for the country ultimately?
No, I don't agree. History will show that a lot of the problems which have arisen with textbook delivery have been organizational problems on the part of government, just getting the books delivered to the school. Allowing wholesale copying can destroy the publishing industry. They're going to go out of business, and then there's going to be nothing to copy. I'm very sympathetic to the socioeconomic needs, but I don't think it's a copyright issue. The focus is being put in the wrong place. It's a lack of attention to sociological considerations by the government of the day.
Sanya, the fears of this publishing market collapsing, they're highly overrated. First, the Competition Commission of South Africa has announced that they are investigating cases of price fixing and unfair competition in the creation of a cartel in over 90 publishers in South Africa. This investigation is based on credible evidence of price fixing and exorbitant prices for textbooks and other educational materials. So that's one thing that needs to be pointed out. The publishing market is a robust market, to say the least. Now, second, the people whom these exceptions address, they are already excluded from the market. They are unable to pay for access at the moment. So securing access for these groups through exceptions will simply democratize access.
We have somebody in the audience who wants to speak up.
When it comes to academic text, a lot of that research is funded by government. You're subsidized. And when that and a lot of institutions actually pay you for your research. And I think it's kind of disingenuous to say that the industry will fail. I mean, I know there was a talk about we should just use the system as it is, TRIPS and the exceptions, and just apply for these licenses. That system has only been used once, and it took around 4 years for the application approval. Currently, Bolivia is trying to do the same with a company in Canada. They have applied to the Canadian government to use the exception in TRIPS, and it has not been approved. They applied in May. The system is unusable, and it has been stated in many, many research texts, and they've said that you can have a thing that looks pretty on the surface, but it's not usable.
Thank you so much. When we return, we will hear more from our audience. Don't go away. Welcome back to the Big Debate. Are strict intellectual property laws necessary to protect the interests of the creators, inventors, and entrepreneurs? Or is it time for a people's vaccine? And copyright exceptions for education? Let's hear your views. Let's start with you, Douglas.
There's a lot of misunderstanding about what fair use is. Being a Wikipedia editor, I know from experience there that using fair use doctrine really tries to protect the copyrights of the copyright owners. And it's really a really rigorous process of trying to argue how using copyrighted material should be excluded because it's in the public benefit. And it's this public benefit that is really the only reasonable sort of exception for copyright. And fair use does a really good job protecting that. I don't buy the argument that it'll tie up the courts and needless litigation. That certainly has not been the American experience. The United States is fair use. Increasingly more and more countries are adopting fair use, such as Singapore and Israel and many others. I do want to sort of touch on something Professor Undine brought up. He talked about the justification for copyright being that it incentivizes creativity through the mechanism of awarding temporary monopolies. I would argue it is in the public benefit to promote creativity. Therefore, the public benefit exception sort of overrides the right for companies to derive a profit from their works, so long as there's a very strong public benefit.
As communities who are in the rural areas, there's no consultation and there's no consent. Whatever the government is doing regarding protecting these copyrights.
I think we have to put this in the context of its restriction on a whole lot of things. Look at like the access to even HPV vaccines in the public sector in South Africa. We don't get the widest coverage against cervical cancers because of it. So we have to find ways to make public goods innovation work for the majority, not just for those who've got the money for very expensive medical products.
I think the most worrying aspect about when South Africa needs to make their bills, especially, the parliament and our president, is all this interference that is always coming from the internationals. We as South African citizens are not given enough opportunity to speak to the kinds of bills that we want and how we want our country to be run, especially when it comes to the fair use clause. Most people that are contesting are international people and the so-called experts. But here we are users of the very same content that they want to protect. So there seems to not be a proper balancing between the creator and the user of the very same content that we're talking about.
It's important that when we look at these things, we consider human lives first before profit. I think the problem that we're facing here is that we have allowed profiteers to dictate to us how vaccines, how intellectual property rights are determined. They need to understand that without us, they can never have profits. For goodness sake, they sell these things to us, and it is important that they begin to understand that we have a say in how the intellectual property rights are determined. Thank you.
Yes, as authors, we do write for profit, but not only for profit, but also for making a living. So now, when you look at this issue of the bill that was passed there to Parliament, it's unfortunate that they use the community of the disabled to lodge their complaints. To the community of the disabled, as a chorus of rustics, we are willing to give our work to you. Let's also have a government that is accountable to the people, a government that is not far detached from the world of the living.
Generations to come, they have to pay loans that were taken by South African government to pay for a vaccine, for instance. And these monopolies are doubling profits, are making more money at the expense of the poor. And those kind of issues are not addressed by those who are talking about intellectual property and blocking the underdeveloped countries in terms of accessing his vaccine.
Thank you. When we return, we hear final words from our panel. Stay with us. Welcome back to the big debate on intellectual property, access to vaccines and education material. Let's hear final thoughts from our panelists. Ivo, I'm going to start with you.
We've heard a lot about incentives. People say, well, people write textbooks for reasons other than financial profit. Well, that might be true, but if you remove the opportunity for financial profit, then you're only going to get those people who are paid to do other things, academics and so on, that are going to write textbooks. The same with online media. You're going to get a lot of people who have day jobs and may have all sorts of agendas that are going to write and are not being paid to be independent. Now, with the pharmaceutical industry, it's exactly the same, right? The pharmaceutical companies generally don't like vaccines. Right? They're actually, on average, less profitable than therapeutic drugs, and they're very risky to develop. There were a few companies here that made it and that made money, but most of them failed. Pharmaceutical stocks have underperformed the rest of the market in the last year. So the idea that you can pull the commercial rights rug out from under these pharmaceutical companies without any implications is just not true.
Andrew Lenz, final thoughts from you?
First, on fair use. I studied in the United States. Fair use is the hidden secret of the United States being so innovative. Fair use is what enables them to make new technologies so much. And as someone who studied there, I don't think it's that hard to predict. As an attorney, I'll be quite happy to litigate fair use cases. If anybody's got any uncertainty, once the cab is passed, I'll be happy to deal with those. Secondly, on medicines, we know that for vaccines to work, as many people in the population get a vaccine needs to get it. The result of not vaccinating the planet means that COVID is not going away. That means that there'll always be a market for Pfizer and Moderna and company to sell their vaccines. It's in their interests to keep COVID alive, to be pro-virus, and thus provide a market for them to keep on having to develop new vaccines. Or they could license those vaccines to countries like South Africa, and we could wipe out the virus.
Thank you for your contributions. Sibongile, your final thoughts.
Everyone has a right to life, and everyone has a right to information. As activists, we are not saying people they shouldn't get any compensation, but we should think of people's life before profit. Because at the end of the day, everyone has to die because that person is poor, the race, the country are coming from, the disability or whatever. So those laws needs to be practiced by everyone globally.
Sanya, your final thoughts.
We are still in the middle of a pandemic. The intellectual property waiver on the international level is urgent, and it will ensure that everyone's right to health is fulfilled. It also includes copyright so that we can access essential research about COVID-19. Now, the second thing, in relation to domestic law, The Copyright Act has already been found to be unconstitutional because of inadequate exceptions for people with disabilities. Reforms are urgent and long overdue. The educational exceptions in the Copyright Amendment Bill are narrowly tailored to the South African context, but very importantly, they give effect to the right to education equally without discrimination. The right to education is an empowerment right that is fundamental to human development and cannot be subordinated to business profits. Copyright is a statute and must be interpreted to give effect to the Bill of Rights and not in a manner that violates it.
Professor Owen Dean, your final thoughts.
The argument was raised that there's no proof that the incentive creates more work being created and that intellectual property has been effective. I would disagree with that, and I think the development that has taken place worldwide over the past century is ample proof of what the benefit of intellectual property is. It's an internationally recognized system that the whole world thinks is worth pursuing. That's why you have all of these treaties and so forth. Only a handful follow the fair use principle, which is very much an American product. It suits the American legal system. It doesn't suit our system. I dispute that our Copyright Act is unconstitutional. In our current act, Section 13, enables anybody who feels that they need an exception to go to the minister, make out a case, and the Minister of Trade and Industry can produce regulations in which he can create exceptions. The blind organization could have gone straight to the minister, forget about amendments to the Copyright Act, which have been stalled. That's in the existing Copyright Act. So why is the existing Copyright Act unconstitutional? It's a myth. It's an emotive argument which gets used by the people who are against the whole system of intellectual property.
Fatima, your final thoughts.
We're not dealing with novels and perfume and jewelry and handbags. We're dealing with life-saving medicines, life-saving information. Even in the copyright realm, we need the right to be able to repair a ventilator for somebody who's got COVID and is hospitalized, but copyright prevents us from doing that. We need access to scientific data, for example. Luckily, we live in a country with a constitution that guarantees the right to health, that trumps all of these other competing claims around the market and its right to make an excessive profit. We have the situation currently of morally grotesque vaccine apartheid. That vaccine apartheid was given rise to by a situation of excessive IP protection. If we're going to address that, and we've got to decommodify life-saving technologies and life-saving information and data and actually take it out of the World Trade System.
Thank you very much. When our intellectual property laws create monopolies and high prices, people's lives are harmed. Hence the call for a waiver of intellectual property during COVID-19. Is it time to rethink the way we regulate access to knowledge and inventions so that everyone can benefit? You decide. I'm Ridi Klabi, and you've been watching The Big Debate.